Hello, this is Harold Weiser with the Weiser Law Firm. I wanted to take a few minutes here to discuss how to modify or change child custody in St. Bernard Parish. Now, as most people would know, St. Bernard Parish has 5 judges. Each of those 5 judges acts independently on how they facilitate different matters in family law scenarios. And one of the biggest family law scenarios is going to be child custody modification or change of custody or whatever terminology that you want to use. And each judge individually likes different methodologies on doing that. But the general facts remain the same. Anyone can file various forms with the court that are already pre-printed that say rule to modify custody or rule to change custody. You put your name, the mother's name, vice versa. Then you put the children's names on there, and then you specify what it is that you're looking for or why you want to change that custody. And again, it goes both ways, from mothers or fathers trying to change the custody specifically because they have issues with the other, with the other parent, and they're not happy with their current custody order that's in place. But the one thing that a lot of people seem to forget when they file on their own is a change in custody is not really automatic. Upon request, you have to go back and look at how the last custody order was done, and it's really important because there are 2 ways that a previous custody order could have been done. Legally, we call it the Bergeron standard, but that's just a court case from Louisiana. That means, did the judge hear a bunch of facts and did the judge make a ruling? The other option is, did the parties get together after a lot of debate and go ahead and agree to something that made a custody order that was in place? Generally, we call it a consent judgment, but it also could have been a very small hearing or something of that nature. If the matter was agreed upon easily, with less of a long hearing, it's easier to have it revised or modified. On the opposite end of it, if one of the judges hears hours of testimony, makes a custody order, they're less likely to want to go ahead and change that. Although there are a couple exceptions in the St. Bernard courthouse. They tend to specifically want to hear everything that the parent has to say before making a new ruling. But going very quickly over some of the elements, it's really the ability to pay for the child. That's a big factor that we come across a lot. The prior relationship, the health of the family, the moral fitness, the stability that is around the children, where have they been previously, their location always comes up. I mean, we have cases from one parent moving to the North Shore, another parent being on the South Shore, and the complications that are there with the inability for one parent to be able to drive back and forth across the Lake Pontchartrain, that do create a lot of problems, and a lot of the past issues that are in the history that are brought into those factions that we put into the hearing. So you want to have a lot of those things in order, and know how you're going to relay them when it comes to filing for your modification of custody. And if you've had a serious hearing previously, you're going to want a good reason to modify. And sometimes those reasons include mental health professional requests, which can include parental coordinators. It can include child custody evaluators, maybe medical reasons on what are happening in the children's school. And unfortunately, we get a lot of Department of Child and Family Service issues, police intervention, drug issues with the parents or people that they're around. I mean, those are the factors that you would want to include in your motion. Once you have all of that prepared, you want to make sure that the motion's filed with the court and the service address is listed on there. So it's really important to have the other party served, and then you go to court. When you go to court, you have to prepare all of your evidence to get it ready for the judge to hear. Of course, there is always a lot of testimony that is just a particular person's point of view versus the other person's point of view. But having additional evidence, expert reports, medical records, school records, different evaluation records, anything like that can be a lot more beneficial to make your case better and to help implement that change in custody or modification that you're in fact trying to do. Our office deals with this consistently, and obviously if you have any questions, you're welcome to give us a call or send us an email.